topic near and dear to my heart. I'm gonna try to keep it brief. The professor in me just wants to make a whole lesson out of everything, right? So we don't have the time to go through the history. And I wanna thank MWBLSA for inviting me. I was very active in BALSA. I was in the southern region of BALSA board, so I know how much work you all are putting into this, and I'm so impressed with what I've seen so far. Thank you so much to my co-panelists. I looked them up and thought, how did I end up on this panel? So, thank you for inviting me, because these two gentlemen have done some awesome things, and it's my pleasure to be here. So I want to talk a little bit about the reform, but I want to lay kind of the groundwork for why we're talking about the need for reform, right? Because everyone doesn't always know what qualified immunity means and what it ends up meaning, practically speaking. So here you see a picture of a young man. I want to give special thanks to Connor D. Porzig, my teaching assistant, who helped me with this, and Ray C. Petty Jr. They're both students at WMU Law School, and I love teaching. I really do, and they just give me so much joy and optimism, which I need in doing this kind of work, right? We're gonna go through some of these stories very lightly, but as you see here, this is Ray Petty Jr. He just graduated, studying for the bar. He's going into JAG. This is his, he was in my program, DAP, that Brandon told you about. This is his graduation picture. He's going to dedicate his career to making sure we have access to justice. And you see people in this picture like George Floyd, Sandra Bland, and others. And he's holding the picture of Breonna Taylor, one of the most shocking cases we've heard recently. And I put No More Stolen Lives because when I was in college, I was a part of a group of people called, a program called No More Stolen Lives, because we had our own list in New York of all the victims of police violence, like Amadou Diallo, like Abner Louima, and going all the way back to when I was younger, my first instance was Rodney King. And I think we all will have stories like that. The first time you heard one of these stories of fatal violence suffered at the hands of citizens by law enforcement, when they themselves were not engaged in any criminal activity. And so qualified immunity is a system that is preventing those individuals from getting a remedy. And that's why we want to talk about reform. So what is it? It's a judicial doctrine, and it shields state actors from liability for misconduct, even when they break the law. Even when they break the law. And it comes from the Supreme Court making it up in a case called Pearson. Pearson v. Ray, 1967, they decide that they're going to apply this idea of good faith as a defense to a case involving a constitutional statutory violation. I want you to pay attention to that date, 1967. You're looking at the tail end of the civil rights movement, a time when people were seeing on TV the violence at the hands of police officers for the first time nationally. Right? Communities of color, particularly Black community, was talking about this for a long time. There's been centuries of it, but during the civil rights movement is the first time you start to see it's televised. So what's happening now? We have smartphones, and we are able to be the ones who televise some of these incidents, like we saw with George Floyd. And so now we're back to this idea of what are we going to do when individuals have constitutional statutory deprivations at the hand of law enforcement? We have to provide them with a remedy. Qualified immunity is used because it allows the government to be immune, not just from liability, but from suit, unless the victim can show both, or the victim's survivors in the cases of fatal cases, unless they can show both a constitutional deprivation and this idea of a clearly established right. So the clearly established right is what's causing a lot of the problems. The practical effect is that we've gone from immunity to impunity. And so our victims of these cases don't have a remedy. And so for the reform, we're looking at things like abolition, indemnification for police officers, the Supreme Court, which I shortened to SCOTUS, right? They created this doctrine. They can, they can destroy it. They can get rid of it. And then I'm going to touch a little bit about some of the objections and my ideas on those objections. And this presentation is, was made available to MWBLSA, so if you want a copy, you can get it. The primary federal civil rights statute that victims of law enforcement official violence is Section 1983 on a federal level, right? It says that violators shall be liable. Shall be liable, that's all it says. And then at some point, the Supreme Court invented this idea of qualified immunity. And you'll see a quote here from Fifth Circuit Judge Willett. Section 1983 meets catch-22, because like I said earlier, this idea of clearly established right is the problem. So the Supreme Court has told you, okay, if you have a constitutional violation, you have to have a clearly established right to that protection. And if you can't show that, then we can't hold these individuals liable. And it creates this catch-22. Supreme Court is aware of this problem. In my research, I've read that a judge from every presidential administration, from the Carter administration to the Trump administration, has come out criticizing qualified immunity. Liberals, progressives, conservatives, they all have problems with this idea of qualified immunity. And I have quotes here from recent Supreme Court justices. Sotomayor said it's an absolute shield for law enforcement. It has gutted the deterrent effect of the Fourth Amendment. Justice Thomas says, we have diverged from the historical inquiry mandated by the statute. He's referring to Section 1983. You see Scalia saying that the jurisprudence has not purported to be faithful to the common law immunities that existed when Section 1983 was enacted, and that the statute presumably was intended to subsume, and Kennedy echoing those same sentiments. So the Supreme Court is aware that this is an issue. And let's look at examples of how qualified immunity has protected law enforcement officials. So it has protected them when they shot a child while the officer was attempting to shoot the family dog. Forced the prisoner to sleep in cells covered in feces for days. Police officers stole over $225,000 worth of property. No liability because of qualified immunity. Body slammed a woman after she simply ignored a deputy's commands and walked away. Seriously burned a woman after detonating a flashbang device in the bedroom where she was sleeping. Deployed a dog against a suspect who claimed that he surrendered by raising his hands in the air. Shot an unarmed woman 8 times after she threw a knife and glass at a police dog attacking her brother. In all of those cases, qualified immunity applied. The victims were not able to pursue their case and get a remedy. So why do we need reform? It should be obvious by now, but here are some other things for you to think about. Cases involving clear violation of constitutional rights have no recourse, because that particular violation was not quote unquote clearly established in the prior case law. Between 2005 and 2012, 1,000 fatal law enforcement official encounters, many more thousands injured. And even law enforcement officers are reporting that it's more dangerous and difficult for them to do their job with all the tensions and without knowing where the clear guidelines are of what they can and cannot do. So some of the efforts at reform: abolish it altogether. This is a recommendation from Jay Schweikert, Cato Institute, about language that can be added to Section 1983 that makes it clear that qualified immunity shall not apply to any cases brought under the statute. Section 1983 was a statute enacted after the Civil War specifically to protect individuals who were formerly enslaved and the Black population, because they knew there would be this mob violence, and they knew that the violence would be in part perpetuated by law enforcement officials, or that the law enforcement officials were a part of those communities. And so they would be caught in between trying to protect their own interests, self-interest in staying safe, and the interests of those who were going to be victims at the hands of the mob violence. And so Congress can amend the statute. And and that takes care of the problem. Another thing you can do is abolish it, but give safe harbors, right? And here's two proposed ones that come out of George Floyd Justice and Policing Act of 2020. So you can say that qualified immunity will not apply unless your conduct was specifically authorized by a state or federal statute and no court had found it unlawful, or if a court in your jurisdiction specifically found the conduct at issue lawful, then you have a safe harbor because you were relying on clearly established law, right? And so that allows the judiciary to give those clear guidelines. It allows law enforcement to know where those lines are. You can also have the Supreme Court overturn itself. They can narrow qualified immunity. They can go back in time and remove this clearly established prong that they created. They can also remove the good faith defense in general. And then you see some states are moving forward with eliminating it. Florida has 2 bills pending right now. Colorado, the governor has signed a bill as SB 20-217. Now that doesn't help with the federal statute, but it's a step in the right direction. Here are some of the common objections you're going to hear to reform. It's unfair to public officials to hold them liable when the law isn't sufficiently clear. But I teach criminal law. One of the first things I teach my students is ignorance of the law is no excuse. So if we're going to hold citizens to that standard, why can't we hold our public officials to those same standards? Risk of liability, which will deter police from doing their jobs. And I've addressed this a little bit. So, you know, I've tried to look for articles written by law enforcement officials and people who represent them to kind of see what their response is. And a lot of them saying it's going to be tougher for us to do our job because we won't be able to execute what we're supposed to do because we're afraid we're going to get sued. But that's why we talk about having the states and the cities who employ them indemnify them, because that's what ends up happening anyway when they are sued and if they're found guilty and liable. And clear guidelines for law enforcement officials helps them do their job better because they're not always making those split-second decisions. They'll know where the lines are. Deterrence of frivolous lawsuits. You know, as a law clerk, I've seen the thousands of cases that come to the courthouse every day. So I understand that is a very serious concern, particularly for the judiciary. But there's already procedural and statutory guidelines in place to deter frivolous lawsuits. And then there's this qualified defense of qualified immunity, right? There's some originalists and constitutional scholars saying, well, we don't want to overturn our prior precedent. The problem, of course, is qualified immunity came from moving away from the precedent, right? That Pearson versus Ray case, before that case, there was no precedent for applying a good faith defense to a claim under Section 1983. So that objection, doesn't carry much weight. So here are some of the sources I used to put together this presentation. If you want to dig deep, you want to nerd out. I know I'm a professor, so I really want to dig into the information. I just wanted to touch on it because now we have a baseline of really understanding what we're talking about. We're not talking about attacking law enforcement officials. We're not talking about defunding the police. We're talking about this very narrow idea of when there is a clear constitutional violation of someone's rights, the victim or the victim survivors should have a remedy. And right now, because of qualified immunity, a lot of them do not. So. But I also want to point out, a lot of when officers, particularly law enforcement officers, are actually they don't get qualified immunity. We get to a final decision. A lot of the cases settle, even the ones that go to trial. The city or county or state, whoever they work for, majority of the time indemnifies the police officer. And so I think this is a red herring to say it's scaring police officers because they're afraid they may be liable. The overwhelming majority of times, they don't end up having to pay anything. And, that's why I think individuals should be really invested in this. Your taxpayer dollars are going to pay for these mistakes and these clear constitutional violations. And so if the cities and the states and the other government entities are making it clear that these behaviors will not be tolerated, we will not be rehiring you in another jurisdiction if you're caught doing constitutional violations on a regular basis like we've seen happening recently, right? It's been coming up in the news. Then the officers and other public officials will start to get in line. What we've talked about are egregious cases. We're not talking about close calls here. Egregious cases. The stealing of the $225,000, really? Like, that has to be clearly established if it's not already. And so the pendulum swung all the way to one extreme. I think it needs to swing all the way back to the other, of eliminating altogether before we can get to something that really is more fair to all the parties involved. Current makeup of the Supreme Court, if it's going to come from the Supreme Court. And then, like, as Judge Reeves described, how long it takes for these cases to get there. And then when the case gets there, it has to be in the perfect posture so that they can actually address this issue and then overturn it. So I agree with Mr. Sultan. I think the states are going to lead the way. They've led the way in so many other changes as well. And the Supreme Court is so loath to overturn itself. But, they overturning themselves would have to be like admitting this big mistake. And the last time we saw that was like Brown versus Board of Ed. It would take that much. And every time there's a new, well-publicized case like Tamir Rice or Philando Castile or, Breonna Taylor, you always think this is going to be the case that's the trigger. And somehow, miraculously, it just has not yet been. And I'm praying we don't get another case that gets worse. But sometimes that's what it takes, the right combination of publicity, the right makeup on the court, a case that reaches them right at the perfect posture, and then they're able to do it. But I do want to encourage everyone to be optimistic. This can be this can be overwhelming. I was doing this research and I'm like, oh man, Judge and Mr. Sultan, y'all went through all those cases and we're like, oh, this is horrible. But we're lawyers. This is what we're empowered to do. And this is why we became lawyers. So especially the students, we're depending on you all to like really rise up, get good at this litigation thing, become clerks like Judge Reeves said, become judges, become litigators like Mr. Sultan, become educators like me so we can help continue this really, really important work.